Hi guys, welcome back to Battle with Ola. This is Mujala Lu and I'm so thrilled to be here once again. Like I said, we want to talk about how to adopt terms of settlement in court today because someone asked that question and we want to answer it today. So I'll quickly go over how we arrive at terms of settlement in litigation and how the court gives effect to it. We're going to be talking about out of court settlement, as the title already implies. Out of court settlement means that a matter has already been filed in court. It might not be filed at all. So if you're settling out of court without recourse to litigation, it's still out of court, but we don't really call that out of court. Out of court in this context means that you have already been to court, you have filed a suit, and then when you go to court, you decided, or the other party decided, that come on, let's settle this thing amicably and let the court give effect to whatever we agree upon. Or the court decides that this matter is something that both of you can settle. So I'm going to give you some time, go and settle it, come back and give me reports. That is what we mean by out of court settlement. When a matter is ongoing, either the court on its own volition and by its own discretion, or parties can decide that we want to settle out of court. So how that happens is that during a proceeding on a day that the matter is slated, probably for hearing or for continuation of hearing, at any stage before judgment, if there are still issues unresolved, you can tell the court, or the court can compel you or advise you, I'm being careful with my words now, that go and settle out of court, go and meet, go and explore ADR, probably mediation or negotiation, and then come back and tell me what you have decided. So in most cases, it's negotiation or mediation that you would employ, because you can't go to arbitration. That's like going to another court on its own, although ADR. So, and usually, if it's a contractual relationship, the terms or the letters of the contract agreement would already state if you should go to if you should go to ADR, if you should go to arbitration or some other form of ADR before even coming to court. But in this instance, the matter has already come to court, and now the court has asked you to go and settle, or you have told the court that you want to go and settle. So the court will adjourn for report of settlement, and usually they will give you a long date where they have assumed, or it is where it is presupposed that within that period you would have been able to have a series of meetings that will generate results, positive results now, and then you come back and tell the court what you have agreed upon. So when you go like that and you have been able to meet and agree, I'm remembering now a divorce proceeding that I was part of several years ago. So the court advised us to go and settle and come back for report of settlement. So we had a series of meetings at a certain restaurant in town. We would agree, we go there, would meet, we would converse, dialogue, sometimes argue until we were able to reach a series of terms. So then we went back to court to tell the court that, oh, we've been able to reach some agreements, but there's one clause that is left, so we want some more time for us to go back, finish, fine-tune that, agree on that, and come back. So we did that, and then when we finally had an agreement, reduced it to writing, and both parties signed, and the lawyer signed, on our side, on the other side, and then we filed it in court, having sealed it. We filed with our lawyer's seal and stamps. We filed it in court. So when we filed it, of course, it's one party that would file. We filed in our own instance, and we were the respondent in that divorce petition. So a party would file, and then we get a date from court, or we already have an adjourned date. On the slated date, you tell the court, may it please the court, you announce your name, O.M. Livingstones, for the respondent in this instance. My lord, so the court will ask that, what's the situation of things, that what's the state of the matter. My lord, based on the court's direction that parties should explore amicable settlement, or parties should settle, or you say, my lord, this case was adjourned for a report of settlement, then the court will ask you, then have you settled? You say, yes, my lord, we've been able to reach some agreements, and we've reduced it into writing, and same has been filed before this honorable court. So my lord will check his file. He has already seen it before anyways, but he will still check his file to see if it's actually there, and say, okay. So then you tell the court, my lord, both parties have agreed to these terms, and we seek to adopt it, before this honorable court and urge your lordship, to enter it as consent judgment in this matter. So when you say that, you sit down, the court will ask the other party if that's the situation, and if they have agreed indeed, and they will say yes, they'll confirm your position. And then if it's something that can be done summarily, the court would adopt it and enter it as consent judgment. If no, the court would give you an adjournment, to pronounce the consent judgment, and then it becomes a judgment of the court. But based on the question that was asked, all you need to do, file the terms of settlement, then on the prescribed date or the slated date, tell the court the situation of things, then tell the court that you seek to adopt it, and you urge the court to enter it as consent judgment in the matter. Then the court will confirm from the other party, and it will be entered as consent judgment, and that is how to adopt terms of settlement. So in another video, we're going to be talking about consent judgments, at length, and we'll probably still talk about some of the things we talked about here. But that's all I have for you in this video. I will see you in my very next video. Don't forget that ADR is always an option. It's always good to settle. Even if you're already in court, make sure you settle. And if you're a lawyer, always try to advise your clients on the option or on the possibility of settling out of court. I will see you in my very next video. Toodles.